Okay, welcome to this video. So, in the previous episode, we were talking about the theory of classical positivism, which is this view that law is the command of a sovereign attached to a sanction. And we saw that that was, at least initially, a very intuitive understanding of the law. It captures the idea that law is about a command. Law is not just kind of advice or just recommendation. Law tells you to do things and insists that you do things or refrain from doing things. It doesn't just give you advice. The law comes from, you have to be careful about this term because we'll see that this is actually a problem for the theory, but it comes from people with the authority to issue law. It's not like just the rules of a club or the rules that my wife and I impose on the kids in the house. That's not law. So it has to come from the sovereign, and it's attached to a sanction. And we saw why that was. That part of the theory was designed to explain why it is that law gives reasons for action. So for many years, people thought this was a great theory and convinced many people. But as I mentioned last time, it's almost universally accepted now that classical positivism is wrong, that it's mistaken. And what we're going to do in this, to start with here, is we're going to look at the reasons why, the main reasons why people think that classical positivism is mistaken. Now, there are other reasons as well that people will point to, but we're just going to look at what are the key reasons. Now, a way to do this, or the way I'm going to do this, is I'm going to do sort of, as it were, two things at once. I'm going to criticize classical positivism, and in doing that, introduce you to modern positivism. And the reason for that is because it's actually quite hard to keep these things separate, or it would be pointless keeping these things separate because it would mean I would have to go over the same material twice, because modern positivism is a development of classical positivism. What the modern positivists said was the classical positivists are right to say that there's this separation between the law as it is and the law as it should be, at least a conceptual distinction there that we always need to keep in mind. Remember from last time that when we're doing legal science, we're looking at the law as it actually is, and when we're doing political philosophy, we're looking at the law as it ought to be. The modern positivists said, I think the classical positivists are totally right about that, but they're wrong about some things, and so we need to improve on their theory, right, in order to get a better version of positivism. Okay, so the criticisms that I'm going to make came from modern positivists, and the modern positivists used that criticism to develop their new theory. So they said, the classical positivists are wrong about this, the right position is such and such. Okay, so it wouldn't make sense to separate the criticism from the developments of the new position, because that's just not how it worked. Okay, all right, so let me introduce you then to the two most important modern positivists. Here they are. So they are Hans Kelsen, who is an Austrian, and H.L.A. Hart, or Herbert Hart, who was is English. Both, as you can see by the dates, both now deceased. Now, just as a little aside here, there are people who wouldn't want to include Hans Kelsen in the list of modern positivists. They would say that maybe he's a classical positivist, or maybe he's a sort of intermediate figure between classical and modern positivism. We don't need to worry about that. I don't think it matters. For our purposes, for the purposes of this investigation, given the way that I'm going to talk about the criticisms of classical positivism, he's very clearly a modern positivist. But it doesn't matter how we classify these things. It's just not important, right? Okay, so, but anyway, with that writer in mind, let's just continue. So there are really two kinds of objections to classical positivism that I want to look at. I think the second one is the really crucial one for our purposes, but the first one is also important. And I think, given what I'm trying to give you here as a kind of a primer in mainstream jurisprudence, it would be, there'd be a big hole in your understanding if I didn't include this. Okay, so what's the first problem with classical positivism, according to the modern positivists? Okay, well, the first problem is that although it might, at least on the surface, look as if classical positivism is able to capture some kinds of law, it's unable to capture many other kinds of law. Okay, so the idea is, let's go back to what the classical positivist view is, right? The classical positivist view is that law is the command of a sovereign attached to a sanction. And at least on the face of it, that seems to fit, for example, criminal law. And the significance of that is that, when most people think of, certainly most lawyers think of law, they just think of criminal law, right? Criminal law is what comes to mind. And criminal law does seem to be commanding, right? Criminal law says, largely, don't do these things. It says don't kill people, don't take people's property, don't, this and that. And the next thing, the statutes are full of rules saying don't do these things. Okay, so that, it seems to fit that model. And there are other areas of the law that classical positivism seems to fit as well. Like, for example, you might say that tort law is of that kind. Now, for people who are not lawyers, tort law is an area of the law that's, in some ways, I am at least originally, primarily a tort lawyer, and I think that there's very, very important differences between tort and criminal law. But at least on the surface, tort is kind of like criminal law, except that instead of with a criminal law, the state pursues an action against the accused, and the result is, if the accused is found guilty, the accused is then punished. In tort law, it's one individual bringing a claim against another individual, and if the to use the language of the law, if the plaintiff or claimant, if you're in the UK, but if the plaintiff establishes a claim against the defendant, then the defendant has to normally compensate the plaintiff for the injury that the plaintiff has suffered. Anyway, that on the face of it looks like it fits the model of classical positivism, because it seems to be saying that there are a list of torts, like negligence and nuisance and assault and battery and trespass to the trespass to the person, there, assault and battery, false imprisonment, and so on. And that you could understand tort law as saying don't do those things. So there's a command there: don't do those things. Okay, but there are so those areas of the law seem to fit the theory of classical positivism, at least at first glance. But there are other areas of the law that don't seem to fit the theory of classical positivism at all well. For example, take the law of wills. So the law of wills is an area of law that tells you how to create a will. It contains a list of rules as to how to create a will, and also a list of rules as to what happens when someone with a will dies. Okay, now that area of the law doesn't seem to be about a command. It doesn't seem to issue commands. It doesn't say you have to do this. No, it does say if you want to create a will, then you have to do these things. But it doesn't say that you have to create a will, right? It just says if you want to create a will, here is how you go about doing it. Okay? So it doesn't look like the law of wills commands you to do anything. It just says that if you want to create a will, here's how you go about doing it. Right now, another area of the law that's relevant in this context is the law of contract. So the law of contract is the area, you probably all know this, but it's the area of the law that deals with legally binding agreements. And there are rules in the law of contract, such as the doctrine of offer and acceptance, that says that, in order to make a legally binding agreement, one person must make an offer and the other person must accept it. Okay, now none of that, the doctrine of offer and acceptance in the law of contract, that does not seem to be a command of the sovereign, right? There's no command there. the law is saying, if you want to make a contract, this is how you have to do it, right? But the law is not saying you have to make a contract. Okay, so there are lots of areas of the law like this. I mean, the law of charities would be another area of the law. There's trust law. There's the law of property, right? There's all these areas of the law that don't seem to be about commands at all. When you first... One of the reasons that the classical positivism is initially appealing to us is because, especially if we're not lawyers ourselves, is that we have the criminal law in our minds, and the theory of classical positivism has a template of law that seems, at least at first glance, to fit the criminal law, but it doesn't seem to fit other areas of the law. I mean, the law of property does not issue commands. The law of property is about who owns what. The law of property doesn't tell you not to steal other people's property. The law of property does not tell you not to touch other people's property. It's the law of tort and the criminal law that does that. The law of property is just the law of whose stuff is whose, right? What belongs to who. It's the law of owning stuff. So there are whole huge areas of the law, right, that don't seem to fit the model of classical positivism at all. Now, in fairness to the classical positivists, they had thought this. It wasn't, only people in the 20th century, right, who started to realise this. John Austin realised that this was a potential problem for his theory, and he came up with an answer to it. So, and think again about, if we go right back to the beginning, about the law of wills. So I said that the law of wills is not about commands, and it's also not about sanctions, right? The law of wills just says, if you want to create a will, here's how you go about doing it. So it doesn't seem to be about commands, and it doesn't seem to be about sanctions. Now, Austin's reply to that is to say, oh, no, there is a sanction there. The sanction is, if you don't obey the rules in the law of wills, then you don't create a will. Right, so there's the sanction. You want to create a will, right, but you don't obey the rules, and the law says that you haven't created a will. So that's the sanction. The problem is that that doesn't really seem to be an adequate answer, because the idea of a sanction seems to be about, it's a punishment. Like you disobey the criminal law, you get punished. But failing to create a will it doesn't look like a punishment at all. Right, it's not as if the law is saying, "Oh, you didn't follow the rules. Here's the punishment. There's no will here." It just says, "No, you just haven't met the formalities. You haven't met the formalities of will formation. There's just no will here. It's not a punishment." The same with contract. If we don't follow the rules in the law of contract to create a contract, the law just says there is no contract here. There is no legally binding agreement. Now that might contradict what I wanted, but it doesn't seem to be right to say that that's a sanction. The law is imposing a sanction, a kind of punishment on me for not following the rules. But the law it's not bothered by the fact that I don't follow the rules, right? It's not saying, you didn't follow the rules, so here's your punishment. It's not saying that at all. It just says, well, you didn't follow the rules, so there's no contract. You didn't follow the rules, so there's no will that came into existence. That's all. So okay, Austin had a reply, but the reply doesn't seem to be very convincing. The other thing is that the reply doesn't really seem to address the issue that these laws aren't commands, right? So the law of contract does, the law of wills, it doesn't look like those laws, the law of offer and acceptance, for example, the law of will formation, doesn't seem to be about commanding at all. And rather, the law is facilitative, right, rather than directive. The law is not saying do this or don't do this. The law is making something possible that otherwise wouldn't be possible, right? The law is making the creation of a will, right, which is a declaration about what will happen to your assets after you die. It's making that possible, right? Because otherwise, without the law of wills, you wouldn't be able to determine what happened with your assets after you died. You'd be dead. Right, so you couldn't decide how your assets would be distributed. The law of wills makes that possible. Right? It doesn't seem to be about commanding anything. It's about facilitating something, making something possible that wouldn't otherwise be possible. And that's true for the law of contract as well. Without a law of contract, we couldn't make legally binding agreements. Right? So the law of contract is not about commanding us to do something. It's about making something possible that wouldn't otherwise be possible, namely legally binding agreements. So it just, okay, Austin's got this reply, and maybe it's, in a sense, a sort of a clever a reply, but it doesn't seem to really address the issue. Okay, so the idea that law is the command of a sovereign attached to a sanction is starting to fall apart now, because it looks like there are whole areas of the law that are not about commands at all and aren't attached to sanctions either. Now, another objection that one could make that I'm not going to talk about is you might also argue that law does not have to be issued by the sovereign. Okay, that's a point that is made, right? I mean, for example, what is one to say about international law, which is, some of it at least is not made by a sovereign. There's also a problem with the sanction there, of course, with international law. Because often there are no sanctions attached to international law. And so on. But I'm going to leave that behind. What I want to do now is talk about a different objection. And this is the objection that I talked about at the end of the previous episode. Okay, so far we've looked at the objection that the theory of classical positivism might possibly be able to explain some law, but it can't explain all law, because there's lots of law that doesn't look like it's about commanding people and isn't attached to a sanction. Okay, but I also mentioned at the end of the last episode, I mentioned that the classical positivism has a theory about the law's normativity. It says the law is normative. Remember, what that means is that the law gives reasons for action. The law gives reasons for action by issuing sanctions. So it says, obey me, or bad things will happen to you. Okay, and what the modern positivist said is that no, that's not the essence of law at all. The essence of law is different. Law is normative. It does give reasons for action, but it's not those kinds of reasons for action that really matter. The kinds of reasons for action that the law gives are not of the kind do it or else, but rather do it because there's a rule that says that you should do it, or if you like, do it because you ought to do it. Okay, do it because you ought to do it. Okay, now this is a very important argument. The force of the argument is to say that law is essentially a matter of obligation. It's not just a matter of do it or else, it's a matter of obligation. If the law says you should do something, you have a legal obligation to do that thing. If the law says you should not do something, you have a legal obligation not to do that thing. Okay, so on this view, the normativity of the law is the normativity of obligation. Law is about obligation, and classical positivism can't explain that. See, classical positivism says, if the law requires me to do something, there's a sanction attached to it. It can say, okay, the reason that I should obey the law is I just don't want the bad thing to happen to me. Okay, but the modern positivists say, but there's more to it than that, because the law says that you should do it because you have an obligation to do it. And the classical positivism has no explanation for that. Okay, now I want to look at the argument for this, but let's just go back to our two figures for a moment. Now, in the English-speaking world, certainly if you pick up a textbook written in English, you're very likely to find that the credit for this argument goes to the guy on the right, H.L.A. Hart. That's not fair. This argument was very clearly invented by Hans Kelsen. In fact, I think it goes back to a philosopher called Immanuel Kant, probably the greatest philosopher in the history of philosophy. And Kelsen, who thought of himself as a neo-Kantian, is picking this argument up from Kant. It's definitely not invented by Hart. Nevertheless, we're going to look at Hart's version of the argument. Why? Because, here I am, I'm speaking in English. I think most of my audience will be English speakers, not all, perhaps, but most of them. And I want this to be useful, this course or whatever, however I should describe what I'm doing here, to be useful for people, for students and so on in the courses they'll be taking. And the likelihood is that in their courses, Hart will be credited with this argument. But it's quite clear that Hart he just lifts this argument from Kelsen. And it's very clear because Hart doesn't really even make much of an effort to change the presentation of the argument. As we'll see in a second, Hart's argument is based on this idea of a gunman, so a person with a gun, right? Whereas Kelsen's argument is based on the idea of a robber band, which is just a whole bunch of people with guns. All right, so it's clear that Hart lifted this argument from Kelsen. So it's really Kelsen that deserves the credit, but for the reasons I explained, right, we're going to look at Hart's version of the argument. Actually, another reason for focusing on Hart's version of the argument is that one of the advantages of Hart's presentation over Kelsen's is that Hart's much easier to read than Kelsen. Kelsen's a much more difficult writer to understand than Hart, and Hart's much clearer. And that's not an insignificant advantage. Okay, so let's start then with a basic statement of Hart's position. So Hart says this: the most prominent general feature of law at all times and places is that its existence means that certain kinds of human conduct are no longer optional, but in some sense obligatory. Okay, so here we see the point that I made earlier, that on this view, law is essentially a matter of obligation. It's not just about do it or else, it's about obligation. So if the law says to me, Alan, don't do something, right, it's not just that the reason I shouldn't do it is because if I do, then bad things will happen to me because I'll get punished. It's also that if the law says to me, don't do something, I have a legal obligation not to do it. Okay, so the idea of law and the idea of obligation are intertwined, and to have a good theory of law is to have a theory that will explain why the law and obligation are connected in this way. Right? That's what needs to be explained, and classical positivism can't do that, so it's not an adequate theory of law. Okay, so let me just give you a concrete example about that. Of course, I have to pay tax. There's a law that requires me to pay tax. Now, it's true, of course, that if I don't pay tax, then I'll get punished, right? I will get fined and maybe even sent to prison for not paying tax. And classical positivism can explain that. But Hart and Kelsen want to say, yes, but there's something else here that's important too, and that is that because there's a law requiring me to pay tax, I have a legal obligation to pay tax, right? And that needs to be explained too. And what's more, right, and again, the classical positivists are missing this out. If I don't pay tax, I will be punished, right? The classical positivists get that right, but they've missed something. What they've missed is that the reason that I will be punished if I don't pay my tax is because I have breached the legal obligation that I had to pay tax. Okay, that is if I'm, say for example, if I'm taken to court and I'm put on trial. This wouldn't happen, of course. It wouldn't, there's no point in it going to court and waste of time. But in principle, I could defend a claim, right, for failing to pay tax. And if it was unclear, if the situation was unclear, maybe it would be worth my while doing so. Right, I would go in front of a court. If the court finds against me and then sentences me to a punishment, right, it will do so on the basis not simply that it has the physical power to punish me, but it will do so on the basis that it is entitled to punish me. It is justified in punishing me because I breached the legal obligation that I had to pay the tax. Okay, so can you see this? That the law is, on this view, which seems right, the law is normative in this way. It's not like do it or else. It's a matter of obligation. I have a legal obligation to pay tax, and if I don't pay, I breach that obligation. And the breach of that obligation is the justification that the law has for imposing a punishment on me. Okay, so it's miles away from just do it or else, right? There's obligations involved, and that's really important. Now let's look at Hart's argument for this. This is the so-called gunman argument. So let's see how it starts. Okay, so Hart says, A orders B to hand over his money and threatens to shoot him if he does not comply. According to the theory of classical positivism, this situation illustrates the notion of obligation or duty in general. Legal obligation is to be found in this situation writ large. A must be the sovereign habitually obeyed, and the orders must be general, prescribing courses of conduct, not single actions. Okay, so what Hart's doing here is he's saying, according to classical positivism, this is what law is like. Law is like a gunman coming up to you with a gun and saying, your money or your life, and you have to hand over the money. Now, okay, there are some differences because in order to be law, the gunman has to be the sovereign, and it has to be sort of doing this all the time, not just doing this on an ad hoc basis. But basically, this is the picture that the classical positivism paints. Right? If according to classical positivism, if the law says I have to pay my tax, that's just like someone holding a gun to my head and saying, your money or your life, right? I have to pay or I suffer the punishment. Okay, but Hart thinks that view is wrong. Why does he think that's wrong? Well, let's turn to that argument. The plausibility of the claim that the gunman situation displays the meaning of obligation lies in the fact that it is certainly one in which we would say that B, if he obeyed, was obliged to hand over his money. It is, however, equally certain that we should misdescribe the situation if we said on these facts that B had an obligation or a duty to hand over the money. Okay. So here Hart's really making the point that we saw, that I made earlier. So he's saying what's missing from classical positivism is the idea that when the tax statute requires me to pay money, I have a legal obligation to pay. When the person holds a gun to my head and says, your money or your life, I don't have an obligation to pay. Right? As he says, I'm obliged to pay in the sense that I have no choice. Or, strictly speaking, I do have a choice. It's just such an unenviable one that we say, I have no choice. So I am sort of forced to hand over the money, right? But so with the gunman, when the gunman holds a gun to my head, I am forced to hand over the money. I am obliged to hand over the money, right? But when the tax law says that I have to pay, it's not just that I'm forced to hand over the money. It's not that I'm obliged to hand over the money. I am obligated to hand over the money. I have an obligation to hand over the money, right? So, and that's crucial to law. Law is about these kinds of things, and I'm just going to expand on this now because law is not only about obligation. It is about norms of this kind. It is about obligations. It is about duties. It is about rights. It is about permissions. It is about powers. It is about that kind of stuff, right? It is not simply about do it or else, right? It is not simply a guy holding a gun to your head and saying, pay your tax or I'll blow your brains out or send you to prison or whatever. It doesn't operate that way. It operates through things like obligations, duties, powers, permissions, rights, and so on. It operates through those things. Okay, now I want a term to capture those things. Right? There's a tendency in the philosophy of law to express this idea by saying that the law is normative. But that's very unfortunate because, as we saw in the previous episode, the classical positivists knew that the law was normative. Right? The law gave reasons for action by issuing sanctions. Right? They knew that the law was normative. The problem with classical positivism is not that they didn't realize that the law is normative. The problem with classical positivism is they weren't able to explain the kind of normativity that the law has. The law doesn't simply work in terms of do it or else. It works in terms of rights, duties, powers, permissions, and all that other stuff. Okay, and so we want a term to refer to rights, duties, powers, permissions, and all that stuff. And the term that I use is deontic power. Law has deontic power. Now, okay, this is just a piece of jargon, and I like to minimize it, but I do try and minimize the use of jargon, but sometimes you just can't avoid it, and this is one that you can't avoid it. Deontology, in the sense that I mean it here, is it just means, for the sake that we're talking about, there's other meanings of the term, but for the sake we're just talking about rules, right? That's all we're talking about. So deontic power, law. So the point, the slogan for capturing this, the significance of the gunman argument, is to say the law has deontic power. Okay, the law doesn't just say do it or else. The law issues obligations, it creates rights, it creates powers, it creates liberties, it creates permissions, right? It creates these things. The slogan, the law has deontic power. Okay, and this is at the heart of, forgive the pun, the heart of modern positivism. The idea that law is not simply a matter of do it or else, it is a matter of deontic power. That's my language, not theirs, but that's their idea. Law is a matter of deontic power. Law carries rights, duties, powers, permissions, and all that other stuff. And we need, if we're going to have an adequate theory of the law, we need a theory that explains the law's deontic power. We need a theory that explains why it is that the law is able to create rights, duties, powers, permissions, and all that other stuff. Okay, now this is very important. This argument, the gunman argument, the argument that law carries deontic power, is of central importance to modern philosophy of law, right? And it's crucial to understand it, right? I think the most important argument in the history of the philosophy of law. Although, as I mentioned last time, I'm actually a critic of this whole way of thinking about stuff. But I agree with this. This seems to me to be absolutely correct. Right, so because of this, I'm not going to talk any more about modern positivism in this video. I think, we've covered enough ground for one episode. We've really looked at the crucial argument. What we're going to do in the next episode is we're going to develop further the theory of modern positivism in connection with this realization that they've had, right? So the realization is that law carries deontic power. It's not simply a matter of do it or else. It's not just a matter of force. It is a matter of force, but not just a matter of force. It also creates rights, duties, powers, permissions, and all that other stuff, all right? And what we're going to talk about in the next episode is how the modern positivist, Hart in particular, takes this idea and builds a theory out of it. Okay, that's for next time. Thanks very much for watching.